Good afternoon, honorable members. Deputy Minister.
Good afternoon, Sharon.
Yeah, good afternoon, colleagues.
Recording in progress.
Let me welcome you back from quite a lengthy period of constituency work and organizational work. I just want to verify who's currently present in the meeting, and I also understand that some members were physical in the NCO plenary today. So just to verify, we have Honorable Smith, Honorable Dodovu, Honorable Mikolakis, Honorable Badenhorst, Honorable Bartlett, Honorable Dlamini, Honorable Ndongeni, Honorable Khadebe. I think Honorable Maleka would probably also join as well. Okay, but I think we formed the necessary quorum for today's meeting. Let me once again welcome you, honorable members, to this meeting. Welcome to the Deputy Minister, as well as the team from the department, the legal team. I think the legal team from Parliament. Yeah, welcome. On members, just in terms of today's meeting, we have 4 agenda items. Gershon, if you could reflect that on the screen. In essence, honourable members, agenda item 1 and 2 deals largely with the judges and magistrates' allowances and benefits. The item agenda 2, obviously, honourable members, we'll get to it after item agenda 1. Item agenda number 3 and 4 on the agenda deals with the hate crimes and the hate speech bill. That being said, honourable members, just going back to agenda item 1, which is where we'll receive a briefing from the Deputy Minister, will actually brief us on the judges and magistrates draft notice determining the rate at which salaries, allowances and benefits are payable to Constitutional Court judges, and magistrates annually. Members will recall that we deal with this matter as well annually, and we do it in terms of Section 2, subsection 4 of the Judges' Remuneration and Condition of Employment Act 47 of 2001 as it relates to judges, and Section 12, subsection 3 of the Magistrates Act as it relates to magistrates. That being said, let me then hand over to DM, Deputy Minister, to brief the committee on the matter, and thereafter we'll engage. DM.
Thanks, Honourable Chairperson, and good afternoon, honourable members. This is basically the process for the judiciary is entitled to such remuneration, salaries, allowances and benefits as determined by the President from time to time by notice in the Gazette, after taking in consideration the recommendations of the Independent Commission for the Remuneration of Public Office Bearers. And there's a requirement that the notice by the President must be submitted to Parliament for approval or disapproval, whether in whole or in part. And so I'm basically, I guess, appearing on behalf of the President's office, presenting the determination by the President on the remuneration of judges and magistrates. The determination by the President is with effect from the 1st of April last year for the 2022-2023 financial year. As the committee should be aware, the Independent Remuneration Commission only gazetted its report with recommendations on the remuneration of all office bearers as required by the Act on the 21st of April this year. So it was somewhat late. That was the remuneration that included the remuneration or the increase remuneration for members of parliament, members of the executive, members of provincial executives, provincial legislatures, councillors, and traditional leaders. But the Independent Remuneration Commission, after having considered, amongst others, the submissions from the various stakeholders, the fiscal condition of the state's wage bill, previous determinations, the impact of the increment on the public office bearers on the fiscus, and the general economic status of the country as it's recovering from the effects of the COVID pandemic, they recommended a 3.8% salary increase to the president for all office bearers for the 22-23 financial year with effect from the 1st of April. Having considered the recommendations of the IRC and the serious economic challenges facing the country, the president is wanting, or basically proposed or determined a 3%, not 3.8 increment for all ranks, for all public office bearers effectively. And so that included judges and magistrates. So effectively, in terms of what you're looking at today, is the proposal by the president for a 3% increment for all ranks of magistrates and judges. On the 28th of June, the president submitted his determination in respect of the remuneration of the judges and magistrates to both houses of parliament. So it is recommended that the Select Committee consider and approve the notices by the president for the 3% increase for all ranks of judges and magistrates with effect from the 1st of April last year, 2022. The National Assembly, the process in the National Assembly is that we've done a similar briefing for the Portfolio Committee, and they have accepted the recommendation. They at the same time did a 3% increase for the Public Protector and Deputy Public Protector and for the Human Rights Commission, but those do not have to come to the NCOP. The NA does that on their own. It will then go to plenary. But Chair, then that's basically the input I think members have got or should have. The determination that the president has made addressed to the chairperson, which includes the draft gazette for both. There's one for the judges, there's one for the magistrates, and they should have the commission's report, which was in the gazette of the 21st of April 2023. So Chair, that's my input. Thank you.
Thank you very much, DM, for that briefing. Honourable members, if there are any questions and or comments that members would like to make in relation to that presentation, please give me an indication. In essence, the president has chosen a 3% increase for magistrates and all judges. Honourable members, if you can give me an indication by the raise your hand function. I'm not seeing any indication. I'm going to then assume, honourable members, that the briefing was pretty much clear to us as members. We don't have any questions for clarity and or comments. In essence, then, honourable members, if you would allow me, and if you find it acceptable, to then deal with the agenda item 2, which is the reports in relation to both notices. And the reason, honourable members, we also want to try and do it in today's meeting, if you find it acceptable, is because this is a very short term. And yeah, in essence, next week as well, the NCOP is on provincial week, so we don't actually have a lot of time in this term to try and process this. If it's okay with honourable members, allow me then to table the first report in relation to the in relation to the judges' remuneration and conditions of employment. The report has been circulated to members as well prior to this meeting. And in relation to to our report, we're saying that the Select Committee on Security and Justice, having considered the draft notice and schedule, determining the rate with effect from the 1st of April 2022, at which salaries, allowances, and benefits are payable to Constitutional Court judges and judges annually for approval by Parliament in terms of Section 2, subsection 4 of the Judges' Remuneration and Conditions of Employment Act 2001, referred to the committee on the 6th of July 2023, we recommend that the Council approves the said draft notice and schedule. Our members, if you're happy with the report and you want to move for the adoption, please give me an indication. Honorable Dodo.
I'd like to say, people, even parliamentarians, they can
Honorable
Thank you very much.
Can you
Thank you
mute?
very much, sir.
Honorable Dodo.
As you indicated,
Honorable
the report
Bartlett.
was
My apologies, Honorable Dodo, because Honorable Bartlett
No,
seems to
sorry,
be
it was a mistake, sorry.
unmuting. Okay. Honorable Dodo.
yes. I was saying, Chair, excuse me for my appearance here in terms of the video. I was saying that you are quite correct to indicate that we did receive the report. We have gone through it. We have considered it. And based on that and based on what the Deputy Minister has briefed us about this afternoon, I move that we adopt this particular report as you tabled it. Thank you very much.
Thank you very much, Honorable Dodo. Honorable Mtetwa, is there any
All right.
second here?
I second Honorable Chairperson, Honorable Bartlett.
Okay, thank you, Honorable Bartlett. Honorable Mtetwa, maybe you'll come in on the next report. Thank you very much, Honorable members. Oh, are there any objections and abstentions, Honorable members? Okay, if there are none, then allow me, Honorable members, to table the second report as it relates to the magistrates. And once again, Honorable members, in terms of our recommendation, we're saying that the Select Committee, having considered the draft notice and schedule determining the rate with effect from the 1st of April 2022, at which salaries, allowances, and benefits are payable to magistrates annually for approval by Parliament in terms of Section 12, subsection 3 of the Magistrates Act 1993, referred to the committee on the 6th of July 2023, recommends that the Council approves the said draft notice and schedule. Once again, honourable members, if you're happy with that report and if you wish to move with adoption, please give me an indication.
I move for adoption of the report, Honorable Chairperson.
Thank you very much,
Honorable
Honourable
Bartlett.
Bartlett. Is there any second?
I second that, Chair.
Thank you very much, Honourable Matsamai. Are there any objections and abstentions? Okay, if not, then honourable members, the report is then duly adopted. And thank you very much, honourable members. Honourable members, we'll then go on to agenda item 3. Members will recall that we received a briefing on the hate crimes bill on the 19th of April 2023. And there were questions that were raised by members in that meeting. And at that time, the DM had tendered an apology to the meeting and had indicated to members then that we would, in a future meeting, get the executive then to respond to specific questions that arose out of that meeting that were raised by committee members. We've provided, or the Secretariat would have provided to the DM's office the issues that were raised. DM, you confirmed that to us as well. And the DM today will want to also respond to some of the questions that were raised in our last meeting. DM?
Thanks, Chair, and good afternoon, members again. Firstly, just apologies for not being able to make that meeting. The ministers delegated responsibility for legislation to me. He was meant to be at the Judicial Services Commission when the committee was meeting, and unfortunately couldn't attend to that due to other business, and then had requested that I stand in for him at the JSC. And the JSC is unfortunately, well, not unfortunately, is not a body that you can pop in and out of. You've got to be there the whole time to listen to the interviews and the questions being asked and answered. So my apologies for not being able to make it. Let me start. I mean, you had the briefing. Let me just start by way of background, and I'll try and be as brief as possible. This is a bill that's been around for some time. I speak under correction, but I think the department first published the bill in 2016 for input as a department. And in that process, I had to engage or attend a number of meetings, particularly engaging with religious leaders on the hate crime aspects, the hate speech aspects. As a result of those engagements, there were quite significant amendments made to the bill, which was then introduced in 2018. So it's even been in Parliament for some time. The bill was approved by the National Assembly by all parties, with the exception of the Democratic Alliance, the Freedom Front Plus, the ACDP, and Al Jamaa. Now, what the bill does is create an offence of hate crime, which is an existing crime committed by a person who is motivated by their prejudice or intolerance towards the victim or the victim's family or the victim's association with or support of a group of persons who share one or more of the characteristics, and which is based on one or more of the actual or perceived characteristics. And then in the definition section of the bill, there is a list of characteristics. It's basically age, albinism, culture, disability, ethnic, social origin, gender, HIV or AIDS status, language, nationality, migrant or refugee status or asylum seekers, occupation or trade, political affiliation or conviction, race, religion, sex, sexual orientation, gender identity or expression or sex characteristics, or skin color. Generally, the offence of hate crime has not been so controversial. It's basically taking existing crimes, making them hate crimes so that they are regarded more seriously, and also that they are properly recorded, because hate is on the rise across the world. The incident at Marselspoort, where some African youngsters was an altercation that they had with some white people at the pool, resulting in I think charges of assault. That would have been, if this bill was in effect, that could have possibly become a hate crime if it could be proved that the motive was dislike of the person's race. So it would elevate a crime from, let's say, assault, or which is not that serious, to actually assault as a hate crime. The more controversial one is then the offence of hate speech. And currently, in terms of our law, we have the Roman Dutch crime of crimen injuria, which has been used to prosecute people. Our view as government is that we need a statutory crime specific for South Africa, rather than relying on a Roman Dutch common law crime of crimen injuria. The other remedy for hate speech is in terms of PAPUDA, the Promotion of Equality and Prevention of Unfair Discrimination Act, where that would be something taken to the Equality Court. It's been raised quite a few times, isn't that sufficient? But we feel that where there are sort of horrific incidents of harmfulness or incitement to harm, or promoting or propagating hatred against a person that's part of a particular group, then the state really has a duty to prosecute, as it does with criminal injuria. We've limited because this does affect issues, and it was one of the questions of finding a balance between freedom of expression and in terms of the issue of freedom of expression, it's balancing of other rights of freedom of dignity. I mean, just to remind honourable members that the Constitution under freedom of expression specifies specifically it doesn't extend to propaganda for war, incitement of imminent violence, or advocacy of hatred that's based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. So that is specifically excluded from free speech in terms of the Constitution. What Popuda had done was to go further, and Popuda was tested in the Kwelane case, where Mr. Kwelane, the late Mr. Kwelane, had written an article, a column that was homophobic. And the Constitutional Court had accepted that that was hate speech, so they'd widened the categories from race, gender, ethnicity, or religion to include homophobia. And the only thing was that they'd said that the requirements, which are the same in Popuda as in this bill that's under section 4A1 and 2, that it must be harmful or incite harm and promote or propagate hatred, that they must be read together. So, and then the grounds basically for hate speech are more limited than the characteristics for a hate crime. It's basically albinism, ethnicity, or ethnic or social origin, gender, HIV or AIDS status, nationality, migrant or refugee status or asylum seekers, race, religion, sex, sexual orientation, gender identity or expression, or sex characteristics or skin color. We limited the grounds to those where we thought there was a real possibility of harm. So if you take albinism, people who have albinism are under threat from some members of our society, and therefore need to be protected from people making adverse or inflammatory comments about albinos, people with albinism, that could result in them being harmed. The requirement for hate speech is you've got to, it's saying something, publishing, it's quite broad, communicating something that could be construed to be harmful or incite harm and promote or propagate hatred. We've then provided for certain categories to have what we'd call a higher bar for proving hate speech. And that is basically artistic creativity, performance or expression, academic or scientific inquiry, fair and accurate reporting in the public interest or the publication of any information, commentary, advertisement or notice, or interpretation and proselytizing or espousing any religious conviction, tenet, belief, teaching, doctrine or writings. So the others the requirement for the crime is harmful or inciting harm and promoting or propagating hatred. Those four categories that I've mentioned, the requirement is similar to the constitutional one as to what is not free speech. You can't advocate hatred that constitutes incitement to cause harm based on one or more of the grounds. So it's got to be constituting incitement to cause harm. Whereas with the others, it can be just harmful. We put that in particularly because of concerns from religious leaders that some of the wording of some of the texts, the religious texts, may be seen to be harmful, particularly to gays and lesbians. And the issue basically would be, our understanding in terms of this test is that you can say negative things about gays and lesbians if you're proselytizing, that would be preaching in church, but even preaching or proselytizing in the street, or going door to door to explain what your religion means, that you can say negative things against gays and lesbians linked to your religion, but you can't incite people to harm them, to cause them harm. And then the other issue is that the other balancing is that the prosecution has to be authorized by the Director of Public Prosecutions. The DPP is the provincial head of the NPA, but they can delegate it, but they've got that responsibility. So, Chair, that's roughly the bill. It then goes on to provide for victim impact statements when the person is the accused is found guilty, for penalties and orders, for the National Director of Public Prosecutions to issue directives on dealing with these cases as the National Commissioner of South African Police, and then reporting and implementation of the Act and a provision on prevention. And it does then in the schedule mean that some of the hate crime matters attract minimum sentences. So they are dealt with, the courts are informed for the purposes of sentencing that Parliament regards these as more serious crimes. Just as far as some of the other issues that people raised, there was the issue around the maximum 8-year sentence for hate speech, and where did that come from? That was not in the introduced bill. That was an amendment that the National Assembly made. And it's a maximum fine, it's not a minimum fine. And the issue was that maybe somebody could say something very bad that ended up inciting people, or could have incited people to attack a whole lot of other people, and that there may be a need for a serious sentence like that. Remember that this is a Section 75 bill, so the NCOP is limited to making recommendations on amendments which then can be accepted or rejected by the National Assembly. They have to accept those amendments effectively. The NCOP doesn't have a veto as in Section 76 bills. Then there were some issues around cultural language being seen as hate speech. There were issues around struggle songs, which have been in the media as more controversial more recently. That's specifically with regard to hate speech. And as I said, the requirements are being harmful or inciting harm and promoting or propagating hatred. Thus far, the courts have said that the song Kill the Boer, Kill the Farmer is not hate speech when it comes to, I think it was a complaint against Mr. Julius Malema, or the Honorable Julius Malema. The court had found that was not hate speech in terms of Papuda, where the wording is similar. That matter is on appeal, so the appellate division may determine differently. If they do or if they don't, it may still be taken to the Constitutional Court. But the courts have tended to to see the historical context of struggle songs, although issues have been raised about, given our fractured and divided society, is it necessary to effectively goad other racial groups? And I think the same would apply culturally. It's got to be at a group of people who have who on particular grounds which I listed and which is more limited. We did not include. We did include political affiliation or conviction as a characteristic for a hate crime. That is because people, unfortunately, still in our country, when it comes to elections and in political competition, people do get attacked and killed on the basis of their political affiliations. However, we did not include that as a ground, in other words, a factor for hate speech, on the basis that we didn't want to curtail the criticism of politicians, for example. So, I mean, maybe just in closing to say that there's been a lot of public interaction with the bill. I think when you had the briefing, you hadn't had any submissions. Particular groups had then come in and made submissions, a large number. Those submissions generally were made to the National Assembly, which deliberated on the bill for some time. We have done a response to those submissions. I'm not sure if you're going to ask them to make oral submissions if they want to, but this issue's it might be new to the NCOP, but it has been debated quite extensively by society. Chair, I think maybe just on this, another factor for the bill, there's a rise of hate in the world, and particularly even in South Africa. This is not meant to be the panacea on racism in South Africa, but it's one of the elements that is there to try and promote a more a society where people are getting on better. It's not going to solve it on its own. We won't solve racism in South Africa until the disparities in wealth and things like that, and education and past is addressed. But it's one of the remedies. Also, internationally, in terms of our treaty reports, we have been encouraged, I think it was in the Convention for the Elimination of Racial Discrimination, to finalize this bill, which, as I said, has been around for some time. Chair, let me end there and see if there are further questions.
Okay. Thank you very much, DM, for the opening inputs of the bill. I think we did miss you in the previous meeting. But also thank you for responding to the questions that members raised. Members, if it's okay with you, I'm going to request that we don't necessarily ask any follow-up questions, largely because we're still going to be dealing with public inputs in terms of this bill. And I'm sure in that process we would be able to cover any other issue that you might have. If it's okay with you, honourable members, if you really have a burning question or a comment, you can raise it. But if not, we can then move on to the next agenda item. Honourable Mikolakis, let me take you, Honourable Mikolakis. Do you have a follow-up question, or can we deal with the next agenda item in procedural matters?
Thank you, Chairperson. Good afternoon. Good afternoon, Deputy Minister. No, Chairperson, I just want to check with you. I don't have a follow-up question right now. I think it's important for us to first hear from those who've made submissions, the members of the public. I would just like to check with you. I gather I don't just want to accept it, but I gather then we will have an opportunity after the public submissions to engage again with the department because some questions might arise from those engagements. And I think it's important for us to then go through this exercise of engaging the department afterwards as well. If you can just confirm that for me. Thank you, Chair.
Yes, Honorable Kolakis, we will be engaging with the department further on the bill and also on the public submissions that have come through. Yeah, Honorable Badenhorst.
Thank you, Chair. Yes, I just wanted to, as a follow-up, if I understand it correctly, the DM alluded to this. Will we be then, as part of that process, have further oral submissions on this bill from specifically the substantive parties that submitted the substantive contributions to this bill?
Okay, all right. That is a procedural matter which I thought we'll deal with in the next agenda item. But now that it is on the table, what I should also indicate, I think there have been a few members that have raised it as well with myself around whether we should open it up for oral submissions. I thought procedurally we'd look at the document, what has come through, and then take a decision thereafter, and also based on what the DM also said. But yeah, I mean, on members, let us deal with the next agenda item as well as the issue that is currently on the table. What we should indicate to you, honorable members, that just in terms of the public participation process, you would have received the document that was put together by our content advisor in a more summary form in terms of the submissions we received on the hate crimes bill. And you'll note that there have been quite a few substantive submissions in terms of the hate crimes bill on that document. But in addition to that, there's just been a lot of interest in this process. We advertised the bill on all media platforms from the 18th of April to the 25th of May. In addition to the 40 substantive submissions, initially we received submissions from individuals that would ordinarily make submissions to Dear SA. Unfortunately, when Dear SA deals with this process, they tend to extract whatever they want to test people's opinions on, and they send it out. But they provide our mailbox to them. So the mailbox gets a bit inundated with a lot of emails, of their survey or whatever it is that they're doing. But we've at least, when this is raised with me, we then wrote to Dear SA, and we've come to an agreement that in future they would make their submission as an input to this process. And they would run their own survey using their own mailboxes, etc., which I think we appreciate that, because I know in the past a lot of their submissions just come to us, and it does cause delays administratively, especially in terms of consolidating and compiling, the kind of information that would come to us. But maybe in addition to that, there were also petitions that we received, but obviously, we're more interested in the more substantive issues that come out. People must tell us why they agree or don't disagree or make any other recommendation which they think, a proposal which they think should be amended to in this bill. And then, well, unlike other times, the FOSA would make their own submission in consultation with their members, but this time I think they as well did something similar to Dear SA, where they got their members to also send things directly to us. So that as well created a delay in terms of consolidations. But anyway, FOSA has made their submission to us. But with them, what has happened is they also provided us with boxes of individual submissions from their members, which also I think administratively the team had to like go through to see like what is this, but yeah. But maybe I should just indicate that the petition that was received is also reflected in the summary document under individuals and faith-based organizations. Honourable members, let me allow the content advisor then to just take us through the submissions received, number one. Then thereafter we can look into this issue of whether we open it up to oral submissions or not. I should indicate that a few members have raised it, but let us, if you allow me to run the process like that, we allow the content advisor then to take us through the 40 substantive submissions, and we can have that discussion. If you're okay, honourable members, I don't see anyone raising a hand. Namit, then I'll request Anthea perhaps to then take us through. Anthea?
Good afternoon, Honourable Chairperson, Honourable Deputy Minister, and Honourable members. I'm going to turn off my video because I've got load shedding, so I just wanted to say hello. Okay, so the Chairperson has already given an overview of the submissions received. You'll note that the document is pretty similar to the document that was sent out to members. However, I've just highlighted key issues so that we can go through this a bit quicker. Sorry, Gershwin, can you just move so that I can see the left-hand side a bit, sorry? So moving on to the preamble, the Association of Christian Media for South Africa and the Hate Crimes Working Group stated that the preamble is unbalanced and references some rights but not all. Suggestions were made that the preamble should also cite certain sections of the Constitution and the Universal Declaration of Human Rights, as well as international human rights instruments. Moving on to clause 1, definitions. The Western Cape government, the use of the word substantial and severe in the definition of harm will pose problems of interpretation. We should reconsider the definition of harm in light of the tests laid down in case law as to the meaning of harm within the context of hate speech. We should also correct asylum seekers to asylum seeker status. Lombard forensic accountants, also on clause 1, said the definition of what is hate is not defined. Terms like social cohesion is dangerous, and basically this accountants organization has rejected this legislation. Gershwin, if you can move on. For SA, so the definition of harm fails to meet the Rabat threshold test. The bill's definition of harm also contains elements open to subjective assessments. You will see a list of organizations highlighted. Alongside that, those are all the different organizations who supported a similar submission. Then 4SA gives a definition of harm and a definition of hatred. You can see also supported by different organizations. The SHRC, an Association of Christian Media, it is recommended that the prohibited grounds should mirror those of Section 16(2)(c) of the Constitution. The Commission further recommends that the bill is synergized with PAPUDA to avoid 3 different sets of grounds relating to prohibited speech. In terms of the Hate Crimes Working Group and 4SA, they suggest the inclusion of the term associates in the definition section, defined as family members, colleagues, friends, and other possible connections to a victim. Bona fide, while this term is easily understood by legal practitioners, it is not a common term in everyday parlance. They submit that its use in Section 4(2) of the bill requires that it either be added to the definition section of the bill or replaced with a more commonly understood term, good faith. FAFSA welcomes the inclusion of the grounds, gender identity or expression or sex characteristics. Gershwin, you can move on, please. The Association of Christian Media. The list of proposed 10 of grounds should be narrower. The term intersex used in previous drafts of the bill is preferred to the confusing term sex characteristics. Social origin is a vague term that is not unprotected by Section 16(2) of the Constitution. Social detriment is a proposal to delete or narrow the definition, promote, propagate, or advocate proposal to add definition and sexual orientation. And you will note in your document that they have in fact given words and recommendations for such definitions. Then the Democratic Alliance, FW, de Klerk Foundation, Free Speech of South Africa, Association of Muslim Advocates and Lawyers, and the Islamic Forum Azad Bill. The definition of harm as contained in the bill is both vague and broad. Victim also needs to be properly defined in order to address the broad and vague nature of the bill. Hate should also be clearly defined in the bill. It is not good law to leave such a fundamental element to the crime open to interpretation by courts or through legal precedent if it can be clearly defined within the bill itself. The FW de Klerk Foundation is concerned over the lack of definitions for the key elements such as prejudice and intolerance. They recommend that the definition of a victim should not include juristic persons because hate crimes are motivated by aversion to characteristics such as race, gender, religion, or sexual orientation inherent in natural persons. The African Christian Democratic Party recommends that the definition of grounds should be limited to those mentioned under Section 16(2) of the Constitution. The organizations highlighted support that recommendation. Media Monitoring Africa, Google, and the Catholic Parliamentary Liaison Office. The bill does not currently include the following grounds: pregnancy, marital status, conscience, belief, and birth. The MMA supports the inclusion of sex worker as a specific category in this provision. The inclusion of political affiliation or conviction as a category could result in powerful political groupings or professional politicians seeking protection against fair criticism under this provision. Gershwin, if you can please move on. Thanks. Accordingly, they recommend that the political affiliation or conviction category be removed. ADF International, in essence, hate speech is not strictly defined and lacks objectively determinable criteria. The Autumn Institute, there have been numerous incidents of corrective rape of lesbians in recent years in South Africa. However, the bill is not clear and does not mention or categorize corrective rape. COSATU supports the definition of harm in the bill. However, the Federation is concerned that it omits cultural harm. The bill does recognize hate speech and hate crimes that impact upon culture. The suggestion is to insert the word cultural after social and before economic harm in the definition of harm in clause 1 of the bill. Google. The meaning of intersex is adequately provided for by the inclusion of gender identity in Section 3(1)(h). The definition of intersex should be deleted in its entirety from the bill. The Scalabrini Centre, Cape Town, in Section 1, under definitions of the grounds point E and characteristic point I, they appreciate the inclusion of asylum seekers. However, it may serve to expand this ground and characteristic to include undocumented people. Moving on to clause 3, the offense of hate crime. Google. The hate crime section set out in Section 3(1) of the bill does not include all of the grounds on which unfair discrimination is prohibited in terms of Section 9 of the Constitution. In their view, the ground should be amended to include pregnancy, marital status, conscience, and belief as grounds in Section 3, subsection 1. And there they set it out. The Hate Crimes Working Group, there should be an express legal obligation on the Director of Public Prosecutions or the delegate to provide written reasons to a complainant or their associates within 3 working days when a decision has been taken to decline to prosecute a charge of hate crime. Gershwin, you can move on, please. They further note that the definition of working days would then need to be included in Section 1 under definitions. In this regard, they would like to note that working days refers to any other day than a Saturday, Sunday, and/or public holiday. In terms of the Western Cape government, their view is that the clause is poorly drafted. They recommend that the clause be reconsidered and define underlying offence in the definition section. In clause 3.1bi, link the word characteristics to a qualifier or noun, which appears to be missing, and reconsider the scope of offences covered under the offence of hate crime. A qualification in relation to the victim is necessary in this clause. And below you'll see, to correct the issues, they suggest wording that the wording must refer to the victim's family member, or the victim's association with or support for a person or a group of persons who share the said characteristics. The Sunni Ulama Council, Gauteng and FW de Klerk Foundation. An important element of a hate crime is the understanding of what hatred is. The misinterpretation of this bill, through its vagueness, not only criminalizes irrationally, but also suppresses legitimate speech. The Center for Social Justice is of the view that xenophobic violence should be explicitly listed as an offence under hate crimes. The Catholic Parliamentary Liaison Office, words in clause 3.1 that are difficult to define or which could result in uncertainty and vagueness. And then they list various questions there around family. What does a family member refer to? And Gershon, if you can just go down, what is meant by association? So they have different questions that they're posing, but they support that prosecutions should be authorized by the DPP. In terms of clause 4, the offence of hate speech, the CRL, Commission International Religious Freedom Roundtable Africa, FW de Klerk, etc., there are already laws such as PAPUDA which deal with hate speech. All of them have a recourse in civil law, not criminal law. And perhaps criminalizing some of these acts can achieve the purpose the other laws failed to achieve, as the cases relating to hatred, discrimination, and intolerance are increasing in South Africa. The Western Cape government recommends the question of alignment between the bill and the hate speech prohibition under PAPUDA must be considered, particularly in relation to the grounds forming the basis of hate speech. The Film and Publication Board acknowledges that the Films and Publications Act of 1996, as amended, defines hate speech, and they mention the definition there. And they are arguing that there is an element of similarity between the two provisions in the two bills. Elita Labantu submits that it is challenging to draw a clear line between hateful speech and protected expression, given the fact that it is a subjective and context-dependent test. South Africa is very diverse in terms of culture, religion, politics, race, among others, which therefore needs a balance to safeguard the limitations placed under hate speech. Islamic Forum, Azadful, Sunni Ulama Council, etc. So they're raising a concern around section 4.2d. In order for it to comply with the provisions of the Constitution, the proviso to the exemption must be removed, in their opinion. There is a need to establish a causal link and the need to establish intent. Both of these requirements are standard requirements of the United Nations. The Democratic Alliance, the creation of a new crime of hate speech and the harsh prison penalties attached to it may result in increased self-regulation of the journalistic profession and the public at large, even when the speech may not fall foul of the provisions of the bill. Heartlines. Given that the bill serves to, amongst other things, criminalize hate speech, a higher standard of proof is required than there would be in a civil case. However, the absence of the need to prove a causal link, combined with the fact that much discretion is afforded to the Director of Public Prosecutions regarding prosecution, it is arguable that especially in cases involving so-called unimportant offenders, the legislation may give rise to erratic or arbitrary application. 4SA. Only harmful speech is excluded. However, since the bill's definition of harm is vague and overbroad, hatred is undefined, and the extended list of persons is wider than the grounds listed in the Constitution and Pepuda. The exemption clause offers very little, if any, practical protection. In terms of the bill, it is not only the original author or communicator who could be found guilty of and punished for the crime of hate speech, but anyone who distributes the hate speech in such a way that it is accessible to the public or the victim. Defining hate speech to expressly excluding private communications as follows, and then they give the recommendation in terms of wording. Clarifying and strengthening the religion's exemption clause 42D, to ensure adequate protection of the constitutional right to religious freedom, including religious expression of all people, not only ministers of religion. In this regard, they propose an amendment expressly providing protection for the right and freedom to receive or impart information or ideas by inserting after clause 42D a new clause 42E, which is then set out there under. Gershwin, you may move on. Thank you. The Association of Christian Media. In section 4.1ai, the words "be harmful" infer the direct harmful impact of the words themselves as separate and different from incite harm in the second part of the same sentence. This is broader than the unprotected speech in section 16.2 of the Bill of Rights, and thus would require motivation in terms of the limitations clause section 36. Less restrictive means include the common law crime of crimen injuria, supported by those organizations highlighted there in bold. Clause 4, subsection 2 purports to protect religious, academic, artistic, and media freedom. Nevertheless, the problematic last sentence that does not advocate hatred that constitutes incitement to cause harm based on one or more of the grounds means it actually only protects against the actual harm of the words spoken, not incitement of others to do harm. The term bona fide narrows protection. The clause already has the qualification of good faith. The term bona fide is often used to describe an accredited professional or member. For example, it may be interpreted to protect only a bona fide journalist in fair or accurate reporting and not a journalist blogger. This is also supported by Google. A person could be prosecuted for publishing something they wish to point out for purposes of removal. They suggest the Canadian hate speech law includes an exemption, which they quote, intended to point out for the purpose of removal matters producing or tending to produce feelings of hatred toward an unidentifiable group. The Catholic Parliamentary Liaison Office, clause 4.1a, subsection I, refers to communications that have a clear intention to be harmful or to incite harm. In turn, harm is defined in clause 1 as any emotional, psychological, physical, social, or economic harm. The word any in this definition indicates that even very minor or trivial degrees of harm would qualify as hate speech. We note that clause 4, subsection 2 excludes certain activities from the strict prohibitions contained in clause 4, subsection 1. These exclusions include artistic creativity, academic inquiry, reporting and commentary, and religious interpretation and proselytizing. We submit that the only answer to the problem is to subject all speech, regardless of who utters it, to the test set out in section 16, subsection 2 of the Constitution. And there they provide input as to how this should be done. They also say that if the bill is to be proceeded with, they support the provision in clause 4, subsection 3 to the effect that any prosecution or hate speech must be authorized by the relevant DPP. The Association of Muslim Advocates and Lawyers United Ulama Council of South Africa. After careful consideration of section 4, subsection 1 of the bill, they see that the usage of the word harm is not only layered and patterned, but it is also amplified multiple times in the bill. Any scholar of constitutional law, however, will be loath to confine the term harm to a specific category. The following forms of harm are considered: emotional harm, psychological harm, physical harm, social and economic harm. In terms of section 4, subsection 2, the offence of hate speech does not apply if it is done in good faith. Both Section 1 and Section 4, according to these organizations, lack clarity in defining specific types of conduct that would be considered as good faith. Google. The hate speech provision in Section 4, subsection 1, subsection A does not include definitions of publish, propagate, and advocate. They submit that definitions of these terms be included in the bill for certainty and clarity. They note that Section 4, subsection 2, subsection D, which exempts good faith interpretations of religious texts from being considered as hate speech, is overly broad and submit its deletion in its entirety. The Ecumenical Leadership Council. They contend that the definition of hate speech provided by the bill is too broad and unjustified. They also are of the view that the offence of hate speech it contemplates does not comply with the requirements of Section 16 of the Constitution. The hate speech provisions in the bill, according to this council, are manifestly unconstitutional. The Centre for Social Justice, on the list of grounds that are considered as hate speech, there ought to be inclusion of gender in its broad interpretation in order to capture potential victims and grounds that are harmful within the context of gender equality and gender justice. Further to that, as reiterated under the offence of hate crimes, xenophobia should be included as a potential ground of hate speech. F.W. de Klerk. They found that Clause 4.1a unreasonably and unjustifiably limits the right to freedom of expression, and they submit that the subsequent clauses, to the extent that they rely on Clause 4.1a, are also unconstitutional. They submit that the current version of the offence of hate speech should be removed from the bill so that the criminalization of hate crimes as a distinct crime is not further delayed. Gershon, you may move on, please. We Are Tomorrow Global Partnership proposes 2 amendments, the inclusion of online hate speech and the recognition of intersectionality. The After AFRI Forum proposes wording and to replace the current definition in Section 4 of the bill. Gershon, if you can move down, please. Thank you. The ACDP. The bill's definition of hate speech is far wider than set out in the Kolani judgment. It's also supported by the Free Speech Union of South Africa. The bill creates the untenable situation that it is easier to go to jail for 8 years for the crime of hate speech than to be ordered to apologize under Papuda. They recommend that the wording of Section 16.2 should have been followed where applicable, and that the words "be harmful" be deleted to bring it in line with Section 16.2 of the Constitution. The Free Speech Union of South Africa. The bill's wider definition of hate speech must be replaced by terms contained in Section 16.2c of the Constitution verbatim preferred. An additional exemption for sincere political expression not extending to advocacy or incitement of physical harm should also be added. The ACDP are concerned that the religious exemption in Section 4.2d does not go far enough and recommends the insertion of the words by a religious organization or an individual in public or in private. They are also concerned that the proviso to Section 4.2, which states does not advocate hatred that constitutes incitement to cause harm based on one or more of the grounds, results in the exemption being self-defeating. They recommend that this proviso either be deleted or that the word physical be inserted before the word harm in the proviso. So basically, the ACDP is really wanting strengthening of the religious exemption clause. Media Monitoring Africa. They submit that the extension of the prohibition to the private sphere is an excessive limitation on the right to privacy that is incongruent with its purpose. They submit that the bill should include a proviso to Section 4.1, which makes clear that the prohibition of hate speech does not apply to private communication. they submit that the bill should establish hateful intent as a compulsory aggravating factor in sentencing for existing offences rather than separate offences. ADF International. As a result of the definitional complexities relating to hate speech, law enforcement agencies will face difficulties in identifying whether there is sufficient evidence to prosecute. You may move on. Thanks, Kosha. Campaign for Free Expression. The CFE contains as its main submission that Clause 4 should be deleted in its entirety. The offences in Clause 4 are not necessary in their view in order to curb hate speech, and there are less restrictive means of effectively dealing with hate speech that already exist in our law. And there they give further points in, as I'm sure members have read. The South African Human Rights Commission, Clause 4, subsection 3. The Commission recommends that the bill stipulates that the criminal route would be reserved for serious cases which ought to be proven beyond reasonable doubt. Similarly, less serious cases must be addressed by other means, for example, through the Equality Court, which enables mediation. While the Commission welcomes the introduction of Clause 4.3, it recommends that the DPP should be guided in his or her decision whether to approve criminal prosecution in such matters by some guidance and reference to the seriousness of the hate speech offence in question. The Commission therefore recommends that the clause reads as follows, as members can then see. Video Monitoring Association. Here, in essence, that Clause 4.2d, the religious exemption clause, also be strengthened, as previous commentators have said, and once again, they propose wording. Moving on to Clause 5, Victim Impact Statement. Centre for Social Justice. Community grassroots organizations that work in communities on issues related to violence and its prevention should be recognized as having the ability to assist victims in preparation of statements on crimes of hate, including hate speech. Can you move further down, please, Gersh? Thank you. Western Cape Government. It is suggested that Clause 5 be broadened and that consideration be given to a set of possible circumstances where the victim is unable to authorize the making of a victim impact statement. Clause 5 does not make provision for a viva voce victim impact statement to be adduced in court. The rationale for a written victim impact statement needs to be clarified in Clause 5. Clause 5.2b requires of the prosecutor to provide reasons for the absence of a victim impact statement. A proactive approach requires the alternative method of calling the victim to testify on the impact of the offence. It is proposed that Clause 5 makes provision for the prosecutor to call a victim as a witness to adduce viva voce evidence on the impact of the offence. Calabrini Centre, Cape Town. Hate crimes in general and in the context of vulnerable migrants often lead to the death of the victim. As the section currently provides, the deceased migrant would neither be able to give a victim impact statement nor authorize another person to do so on their behalf. The prosecutor should therefore be required by Section 5 of the bill to obtain expert input either from the group to which the victim belonged or from organizations which work directly with the group to which the victim belonged. Furthermore, that the prosecutor should be required to explain the absence of such a statement in the case of the death of the victim, also supported by the Hate Crimes Working. The South African Jewish Board of Directors suggests the inclusion of a community impact statement in addition to the victim impact statement. The Crown Prosecution Service in the United Kingdom describes a community impact statement as a short document illustrating the concerns and priorities of a specific community over a set time period. The Hate Crimes Working Group, they provide wording there in terms of Section 5, subsection 1, which members can read through. Gershwin, you can go on. They do say, however, that they submit that the victim impact statement must extend to someone authorized by the victim to make such a statement on behalf of the victim. In the event of the victim's death, the victim's associate or associate, an organization or institution with expert knowledge or experience of the group to which the victim belongs or is perceived to belong, and they suggest wording. Moving on to clause 6, which is in relation to penalties or orders, ilito labantu. The sentences upon conviction provided for in this bill indicate a commitment to ensure that a society envisaged by the Constitution is realizable. The South African Jewish Board of Deputies supports the separate minimum framework for hate crime. Ecumenical Leadership Council. They support the fact that the bill introduces harsher punishment for crimes motivated by hatred. The Film and Publication Board. The offences and penalties listed in the Films and Publications Act of 1996 as amended appear to be more detailed, noting the lack of provision of the maximum fine that may be imposed under the Hate Crimes Bill. The South African Human Rights Commission. The Commission is of the view that imprisonment for a period up to 8 years, even as a maximum penalty, may exceed those of other state parties to the ICID. The Commission is concerned that the bill may give the impression that a court may issue a reprimand to a person who commits a hate crime, but this option is unavailable in the case of a person who is convicted of hate speech. The Commission therefore recommends that penalties for hate crimes and hate speech be similarly addressed in the bill. For South Africa Heartlines and all the other organizations, the current version of the bill proposes a maximum jail sentence of 8 years for the first offense of hate speech. This is a very harsh sentence for the first offense of hate speech, and they suggest inserting the following subclause as clause 6.3b to include and require the consideration of the 6-part UN Rabat Plan of Action threshold test in determining sentencing, and the wording is included therein. Google and the ACDP. The proposed penalties under the bill are unlikely to address the vulnerability of groups often subjected to hate crimes and hate speech. They are of the view that Section 6 of the bill includes references to restorative and rehabilitative justice in the form of financial, emotional, and community reparations. And there they once again recommend and suggest wording to be inserted. Association of Christian Media. Section 6 of the bill provides for up to 8 years in prison for the first offense. Up to 8 years is more than the penalty for housebreaking. By comparison, the maximum penalty in Canada is 2 years. Centre for Social Justice. The concern in this section relates to the absence of the recognition of African traditional conflict resolution methods in resolving hate crime and hate speech. Retributive justice and restorative justice through integration within the justice system could provide plausible avenues of addressing hate crimes and hate speech. We Are Tomorrow Global Partnership. The penalties for hate crimes and hate speech in the bill should be strengthened in order to serve as a stronger deterrent. COSATU welcomes the increase in penalties to up to 8 years in prison. The AfriForum, Democratic Alliance Association of Muslim Advocates and Lawyers, argued that the prohibition in the bill is a severe infringement on the right because of the penalty that it imposes and the perturbing effect it has on freedom of expression, and proposes different wording to be inserted therein. The Council of Charismatic Churches says that it cannot be appropriate for a pure hate speech offense to bear the same weight of hate crime if hate speech and hate crime are differently defined by this proposed. You can move on, Gershwin. Thank you. Clause 7, National Instructions and Directives. The Western Cape government, they're merely pointing out a typographical error in Clause 7 to AI, and they're proposing an amendment. Then Google and South African Jewish Board of Directors say Section 7 of the bill should be amended to include a time period in which the National Director of Public Prosecutions should issue directives in terms of the bill. They submit that the section be amended to allow for a period of 90 days in which directives must be issued. Elite Labantu, they welcome the coordination and the collaboration among SAPS, DOJ and NPA, and they submit that in terms of training, that it should be done with SAPS and the NPA. The Centre for Social Justice, prosecutorial directives are provided for as a possibility by the National Director of Public Prosecutions regarding approaches to prosecuting hate crimes and speech. Special education, similar to the Equality Court prescriptions, is not included. Clause 8, reporting on the implementation of the Act. The South African Jewish Board of Directors submits that introducing a time frame for making these regulations is necessary to ensure the effective implementation of the bill. The Hate Crimes Working Group and Centre for Social Justice supports the provisions of Section 8. However, they submit due to the public interest nature of hate crimes and hate speech in South Africa, Section 8, subsection 2 must be equally extended to the public. Therefore, the information contemplated by Section 8, subsection 1 must be available to the South African public, and there they propose the wording that they're recommending should be inserted. Clause 9, prevention of hate crime and hate speech. The South African Jewish Board of Deputies and Elite Labantu, they note that key departments have not been expressly listed, and they also submit that the duty to cause programs to be developed is too vague. The Hate Crimes Working Group supports the provisions of Section 9 and suggests that adequate funding is allocated to strengthen the work of the awareness campaigns and training of officials. Experts in sexual orientation, gender identity, and sex characteristics should be consulted along with civil society organizations with experience in these areas. Cause for justice. So they're referring to social context training, and they're saying that the bill does not provide any definition for this highly ambiguous and controversial concept. They submit that it would be irresponsible to keep any references to social context training in the bill. All references to social context training should be deleted. Centre for Social Justice. Education on hate crimes is mandated as a measure aimed at prevention and appropriate handling of such matters by responsible prosecutorial and other officials, but it is not made mandatory that only appropriately trained officers and officials should handle such matters. The last clause that we got commentation on is clause 10, which is the regulation. Association of Christian Media and for South Africa states that the bill makes provisions for regulations to be deemed approved within 60 days after having been referred to Parliament. This will grant the executive the power to make regulations without Parliament having the opportunity to consider and approve them. This oversight, in their view, should be remedied to allow Parliament an adequate opportunity to provide the necessary oversight over regulations. The Act will result in substantial additional costs to SAPS and the NPA. It's also the recommendation that prior to approving the bill, the cabinet member responsible for finance should be requested to approve a budget for the implementation of the bill after consulting with SAPS and the NPA. Members, in your document, you'll note that I listed all the different organizations with their general comments, but just for the purposes of the presentation, I've just summarized all these organizations' comments. Recommendation that a working group on hate speech should be established to conduct a proper review on current legislative remedies relating to hate speech. Submission that an urgent reform of the Equality Act is required to ensure it is aligned with Section 16, subsection 2C of the Constitution, and that appropriate remedies are provided in terms of the Equality Act reflecting the nature of such prohibition. That effective training programs be implemented in respect of the bill, that meaningful data collection is undertaken in respect of the bill, and that restorative and alternative justice forms part of education and information campaigns. Chair, thank you very much. I bring me to the end of my presentation.
Thank you very much, Anthea, for that presentation. I'm sure it wasn't very easy to put that summary together. But members, this is just the summary of the substantive submissions that we received. Members have also received either through electronic means or whatever other method they've raised with Gershwin, they would have received the original submissions as well. Members, this is just for your noting, and that you can actually at your own time also go through the submissions. I don't think we're not going to take any questions, etc. I mean, this is just a summary of the submissions that we received. We can then perhaps just deal with the other aspect of oral submissions, which I think a few members have raised and repeated also now on the platform as well. Members, if you do not, I know this is a Section 75(4). As the NCOP, we would only make recommendations to the National Assembly on this bill, but I think there is a feeling that we should open it up to, in addition to the written submissions we've received, we open it up to oral submissions. So, oral members, if you are in agreement with that, I propose we then allow our administrative team then to take that process forward. If you're having, Honorable Mikolakis, I see your hand is up. But yeah, if you're having any issues as well, you can just raise it as well. Honorable Mikolakis.
Thank you very much, Chairperson, and also thank you to Anthea and Gershwin for the information that we received. I see that the emails we received with the documents itself is 5 batches of emails, which indicates also that there is quite a lot of interest from the public, but there are quite a few issues as well that we need to clarify. I, for my part, have a few questions, not only for the department, but also for some of the organizations that made submissions. And I do think that the opportunity for us to engage with them and ask those questions would be very important for us to also be able to apply our minds to some of the questions that we might have. So I would very much support that, and also just wish to thank Anthea and Gershwin for their support in this regard. Thank you.
No, thank you very much, Honorable Mikolakis. I think there are no objections to that process of opening it to oral submissions. You do have the written submissions. Will allow then the public to come in based on the written submissions to make an oral input. And we'll inform members accordingly once we're done with the administrative process. But I must just remind members, next week we are on Provincial Week, so it leaves the other week, which we will try. I think by that week, try and ensure that we try and deal with the oral submission so that we can take this very important bill forward. That said, honourable members, I think we've come to the end of our meeting. I don't know if the DM is still with us, but let me thank you very much, DM, for joining the meeting and for your various OER and for the briefings. And let me also thank the staff that are present here from both the department and from Parliament, the legal teams, for your attendance of the meeting. Members, like I said, in our next meeting of the committee, we will then take this process of dealing with this bill forward. So like I said, it won't be next week, but probably the following week, and it will also allow us administratively to get everything else in order. That said, members, let me not keep you up any further, and thank you very much. This meeting is adjourned. Thanks.
Thank you very much, Chair.
Chair.